So let's talk about something we've all seen in movies and on TV, the courtroom drama. There's always that moment, right? But what's really going on behind the scenes? Well, today we're pulling back the curtain on evidence law. This is basically the rulebook for what's allowed in front of a judge and jury. It's the whole process that takes a simple claim and turns it into legally recognized proof.
Yeah, you've definitely seen it. The lawyer stands up, points a finger, and dramatically yells, "Objection." But what's really behind that? I mean, why can't a lawyer just, I don't know, throw everything they have at the jury and just see what sticks? Well, there's a really good reason, and it all comes down to a strict set of rules. And these rules are all designed for one thing: fairness. And today, we're going to unpack them.
All right, so here's what we've got on the docket today. First, we'll cover the basic rules of the game. Then, we'll figure out who actually gets to testify. After that, we'll look at the proof itself, everything from paper and pixels. We'll even touch on some facts that, believe it or not, need no proof. And finally, we'll tie it all together with the ultimate rule: fairness.
So let's get into the first big rule, the foundation of everything, really. It's actually pretty simple. If you want the court to believe something as a fact, you've got to prove it. You can't just stand up and say, "Hey, this happened." Nope. You have to bring evidence that formally backs it up. You can almost think of it like a ticket to get into the courtroom. If your fact doesn't have evidence, it's not getting in. Okay, so facts need evidence. But who gets to present that evidence? It's not as easy as just pointing to someone and saying, "You're up." There are a couple of really important legal ideas we need to get our heads around: competence and compellability. Now, they sound alike, I know, but trust me, they're worlds apart. All right, first up, competence. All this means is whether someone is legally allowed to give evidence. Can they even take the stand? And here's the surprising part. The default answer, thanks to a law from 1999, is yes. The court starts by assuming that pretty much everyone is competent to testify, and that includes kids. Age isn't the barrier it once was. But look, just because you can testify doesn't mean you have to. That brings us to the next hurdle: compellability. A witness is compellable if a court can legally force them to give evidence, whether they want to or not. Generally, if you're competent, you're also compellable. But, and this is where it gets interesting, there are a few pretty fascinating exceptions to that rule. So, to break it down really simply, competence asks, can you testify? Compellability asks, must you testify? It's ability versus obligation. Two totally separate questions, and a witness might have to clear both. So, who are these people who can't be forced to testify? Well, it's a pretty exclusive club. We're talking about the sovereign, the king or queen, and other heads of state. They're competent, sure, but they are not compellable. Same goes for diplomats with immunity. And then there are some very specific, limited situations where you can't be forced to testify against your own spouse or civil partner. And what about kids? It's a question that comes up a lot. Today, the rule is crystal clear. Their age doesn't matter. It's not about how old they are. Instead, the court just asks two simple questions. One, can the child understand the questions being asked? And two, can they give answers that make sense? If it's a yes to both, then they are competent to testify. Simple as that. All right, so we've talked about the people giving evidence. Now let's switch gears and talk about the things they bring with them. The actual proof. And these days, that can be anything from an old handwritten letter to a stream of digital files. Objects and documents play a massive role in pretty much every modern trial. So let's start with documentary evidence. Now, this is basically anything that has information recorded on it. Could be a formal contract, a quick text message, an email, you name it. The key here is that you're trying to prove the content is true, what's actually written in the document. And to do that, you usually have to show the court the original, or at least a copy that you can prove is legit. And of course, in our totally digital world, the idea of a document has just exploded. I mean, think about it. Our computers, our phones, they are constantly recording information about us. So the law has really had to scramble to keep up and figure out how to treat all these digital records, almost like they're witnesses themselves. But you can't just dump a bunch of computer data in court. There are specific rules. For that evidence to be allowed, the court has to be pretty sure of a few things. Was the computer working okay at the time? Was it being used correctly? And, this is a big one, if a human put the information into the computer in the first place, was that information accurate? Okay, so that's documentary evidence. What about real evidence? What's the difference? Well, real evidence is about physical stuff you can show the court. The classic examples are things like a weapon or a bloody shirt.
But what's really important for us today is that it also includes data that's recorded automatically, without any human typing it in. The focus isn't on the content, but on the object itself. And we see this all the time now. Think about CCTV footage, or even just the automatic time and date stamp on an email. Those are perfect examples of modern real evidence. And why is that? Because a machine created that record automatically. There was no direct human finger on the keyboard, so to speak. It's like a digital footprint of an event.
Okay, remember that big rule we started with? The one that says every single fact has to be proven? Well, like any good rule, this one has a couple of exceptions. There are actually two ways a fact can get into court without needing a shred of evidence to back it up. Okay, the first one is called judicial notice. This is for facts that are just so completely obvious that it would be ridiculous to waste time proving them. You know, like the facts that pigs can't fly. The court just takes notice of it. The second way is with a formal admission. This is way more common. It's simply when the prosecution and the defense both agree in writing that a certain fact is true. So, no need to argue about it. And don't underestimate how powerful a formal admission is. Once a fact is admitted like that, boom, it's considered 100% proven. Case closed on that point. It's a super important tool for making trials run smoothly because it lets everyone focus their time and energy on the stuff they actually disagree about.
So, we've talked about all these different rules. Who can talk, what they can show, what doesn't need proof, and it might seem like a lot of dry, technical stuff, but it's not. All of these rules are pointing towards one single higher purpose, a massive principle that holds up our entire justice system, the right to a fair trial.
And if you want to get specific, the bedrock, the absolute foundation of all of this, is Article 6 of the European Convention on Human Rights. This one article guarantees every single person the right to a fair trial. And pretty much every rule we've talked about today has been shaped or influenced by that core idea.
And this quote here really gets to the heart of it. It describes a concept called the equality of arms. It basically means the fight has to be fair. The process can't be lopsided. Both sides, the prosecution and the defense, have to get a reasonable shot at presenting their case. Neither one should be at a substantial disadvantage. It's all about balance. Article 6 also gives us a checklist of minimum rights that everyone accused of a crime gets. Things like the presumption of innocence, the right to know exactly what you're being charged with, having enough time to prepare your defense, and having a lawyer to help you. And a huge one, the right to question the witnesses who are testifying against you. These aren't suggestions. They are the non-negotiable parts of any fair trial.
So really, here's the crucial point, the main takeaway from all of this. All these rules of evidence we've been through, they aren't just random annoying hurdles. They are safeguards. They've been carefully built over time to protect the whole system and to make sure that every single trial is first and foremost fair.
Yeah, the goal of all these rules is to create this perfectly level playing field, right? A place where the truth can be found fairly. But, the real world is messy. A busy, complex courtroom full of real, emotional people, well, that's a whole other thing. So it leaves us with one final big question to think about. These rules are aiming for a perfectly fair trial, but in the real world, how close do we actually get?